Good evening, everybody. Welcome to another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, along with my co-host, Julio Vela. Julio, how are you doing this evening?
Very good, sir. Very good. Pleasure to be here.
Yeah, we got a great show tonight, ladies and gentlemen. We got a lot of great topics to get to. Our panel tonight includes Tate Williams, criminal defense lawyer.
Thank you for having me on.
Appreciate you being here. And the Harris County Public Defender himself, Alex Bunin. Alex, appreciate you joining us.
Thank you.
We got a lot to get to tonight, and we're going to have Twitter up all night at HCCLA_TV. You can send us your questions and comments right there. We'll take them live here on the air. We'll also open up the phone line. 713-807-1794 is the number. We got it right there at the bottom of the screen. And you can go to Facebook. You can like us there. You can go to our website, HCCLATV.com. We got a bunch of stuff for you there to check out. We're also got coming up at the 8:30 hour, we have our 60-second law lessons, so you'll want to be sure to tune in for that. But guys, I want to start off tonight. Big news breaking this evening. We got an announcement from the Harris County District Attorney herself, Devin Anderson, about the First Chance program. This has been kind of bandied about here the last year or so, and some agencies implemented it, some didn't. There was kind of some, I guess, discretion to the police department. But now, starting January 2016, the announcement is it's going to be mandatory countywide.
Tate, what is the First Chance program?
Well, the First Chance program puts into effect a law that was basically passed by the legislature nearly 10 years ago. Republican legislature, Republican governor, passed cite and release on low-level misdemeanors, including small amounts of marijuana. When they did that, what they said is that you don't have to arrest somebody, force them to post bond, and then get out of jail. You can just issue them the equivalent of a citation and summons to come to court. Devin Anderson's program takes that a step further in a good way, in that they can cite and release people, and then without actually being formally charged, put them in a diversionary program that allows them to take a course, pay some fees, do some things, and then the case stays filed, or if it has been filed, at least under the pilot program, my understanding was that it would be dismissed. And the important thing is that they can get an expunction at some point.
Yeah, that's what I understand the program to be too. Alex, how does this affect your office? A lot of your office sees misdemeanor cases just like this.
We see misdemeanor cases, but we don't see a lot of possession of marijuana cases. In fact, I went around and asked today who had one,
Did you mean as an arrestee or as a
hey, well, having any clients, and because we only represent seriously mentally ill misdemeanor cases, we've yet to have one of those cases. I am familiar with the program. It was based on an idea that got hatched when a number of us, the district attorney, myself, the sheriff, chief of police, went to see what Seattle was doing. They had a program they called LEAD, which is where they took certain neighborhoods and they worked with the police and the community to try to get people help without getting them arrested. And so based on what they saw there was a meeting. The then Sheriff Adrian Garcia, Chief McClellan, and Devin Anderson got together and agreed on this program. So it was started, yes, just with the sheriff and just with the chief. And there have been a few bumps getting the officers to do that, because one of the options for them is at the scene. They can say to the person, look, we're offering this program, you won't be booked. You'll be taken down, you'll meet with a pretrial services officer. There'll be two options. One could be 60 hours of community service. One is a little bit more intensive for 90 hours. And the case is not ever booked. And that's the ideal way to do it. But they couldn't do that with everyone, so they also did it through the courts and made that offer with the prosecutors in the courts.
Now, Tate, you talked about the expunction aspect of this, and there's a couple issues with that I want to delve into. The first is, if it's just a summons, is it technically an arrest that somebody would then have to move to get expunged?
I don't even think they're getting summons, though.
No.
There is no summons.
There's no summons.
Yeah.
They didn't have the way to administer that. So they went with either giving them the way out with pretrial on the street, or it's just like a regular case. The other ones, they're arrested, they're booked.
Yeah.
And that's why they have to go through an expunction to get it off the record, because it is on the record.
I wonder how it's going to be enforced. Like, okay, so the officer's going to call the DA intake, and DA is going to say, put him on first chance. And what's been happening now, currently, is the non-participatory agencies are saying, no, I'm not putting him on the first chance program. I'm taking him in. I'm booking him. And so that guy shows up to court a day or two later when he can finally make it to court, and suddenly he's in custody and he's missed a couple days of work, and we say, hey, you're first chance eligible. Why didn't somebody talk to you? They didn't take me in. I heard them talking about it. The officer didn't want to comply, and they didn't take me in.
You know, the thing is, though, is what's getting missed here is that the people in other parts of the country have been way ahead of Texas on this for a while, or at least among the legislature actually provided for cite and release, I think, in the '07 legislature. So Harris County's just kind of come up with a program that takes it a step further, and I commend them for doing it. But you have states that are going to wholesale legalization or under certain conditions that make it just like wholesale legalization. So we're still talking about dealing with something that in a lot of places isn't a crime anymore. And we're doing it 8 years after the legislature created a process not to arrest people for low levels of weed. And I never bought the we couldn't do it in the system argument, because every HPD guy can issue a traffic ticket and get you a court date. Every JP court in the county can do the same thing through the sheriff's department. So that, to me, was just kind of a non sequitur. I mean, we put a man on the moon, we put the clerk's office on the internet. They could have figured that out if they really wanted to. It was my opinion on that.
Alex, do you have any idea on how the DA's office is going to enforce that? Like, is intake going to say, well, if you're not going to do the first chance, then we're not going to accept charges?
This is the first time I've heard language about it's mandatory, and I don't think it really can be mandatory. And when we were discussing it early on, it was always the officer has discretion to do what they need to do. So I don't think that really changes. I think what's changed is there's now a policy that the district attorney wants this done. And they're going to roll calls and they're telling the officers, you know, this is what we think is the best way to do it and it should work, and hopefully they'll be buying. But you can never tell the officer, you can't make this arrest. I mean, they can call it, and maybe when they call intake, the district attorney said, look, we don't want that case. And there's some leverage there, but the officer generally always has discretion.
Now, what happens, guys, in a case where there's more than just marijuana, but they're booked on something else, but later that case is dismissed, let's say, and you're right back to the marijuana charge? Do they then get the opportunity to enter into the first chance program upon the other charges being dismissed?
I don't know the answer to that question, but you know, it brings up a similar situation we had with pistols. For years you had the traveling exception, then you had the presumption of the traveling, which required that you not otherwise be engaged in criminal activity. So if somebody had a gun in their glove compartment and they got busted for marijuana or DWI, and you beat the DWI, that you then had this UCW that they would say that the traveling presumption didn't apply because you were driving while intoxicated. And then you're like, well, I wasn't, because you just dumped the case, so you need to dump this one too.
Yeah.
And so I think it's going to be interesting to see how that develops, because a lot of people are going to they could theoretically write into the dismissals on the other cases that terms that would keep that from happening. It creates an expunction problem as well, because the courts of appeals have taken the position that if you have more than one case out of an arrest and one's dismissed and you plead on the other one, you're not entitled to an expunction on the one that's dismissed.
You know, and the language is used is you will not be charged. And so what does that mean, and are there any limitations on expunctions, and what questions are raised? So you're just charged. I think expunction allows for you to not expunge an arrest. Mm-hmm. I think it says arrest, and I don't know if it says any additional charging instruments, but if so, what records are kept and by whom? Because they can't just be taking someone in on the street and then sending them to some building and with no paperwork. I mean,
right. Pretrial services handles all the paperwork on these cases for the ones that are on the street that don't get charged. So there is a record internally, but it's not the kind of record that's going to come up on NCIC or any other local criminal records. Speaking
of the 60 or 90 days, so this is the advice I give my clients when I'm telling them about the program. I say, okay, now you're going to take your piece of paper and you're going to go to the 12th floor. And you're going to be waving it around, and then they're going to set you up with an evaluation. And if you're high risk, you're going to have a longer term, potentially a class, and potentially 8 hours of community service. If you're low risk, you're going to be 60 days, 8 hours community service, case closed. Case dismissed. And then you can call me and we can talk about expunging your record. But when they ask you in this interview, did you have beer for breakfast? Don't say yes. when they're asking you, hey, did you smoke weed this morning? Don't say yes. Say no, because then maybe you'll get the 60 days, your 8 hours community service, and done. But that's just.
One other thing that was announced today, and I don't know if you heard, is that the district attorney wants to extend this to thefts. And so there have been discussions with local merchants, because they're the ones that are the big obstacle to giving shoplifting cases any kind of break. And they've apparently bought in, so they hope to extend this program to misdemeanor theft cases.
Well, and that would be interesting, because a lot of times we get these robo letters on shoplifting cases with the clients where Walmart or somebody else has pled as the victim in this shoplifting case, but then they're also seeking to go after your client civilly.
That's the Texas Theft Liability Act.
Yeah.
And so, it's interesting about this, and I think it's a great program if they put it into effect, is that nobody in any state is talking about legalizing theft. No. So, but you see a lot of young people who get accused of shoplifting, and it's always, it's very rarely in these large things, but it is a problem that, Walmart or Target, even all the way down to your local gun shop has to deal with. And so it causes people real economic damage, but it can also cause damage to one of these young people's lives for the rest of it, because it's not only a crime, it's a crime of moral turpitude.
Exactly. And something like that, even though it's a misdemeanor, obviously, is going to prevent someone from getting something as simple as an apartment later on in life.
Right, especially because there are no secrets on the internet. And things that you could kind of not too many people knew about George Bush or Dick Cheney's DWIs at the time they were running for president and vice president. But now, your background is just a mouse click away.
Well, and that begs another question. So, how are they going to handle the public record aspect of this? If you get into the First Chance program right away, I mean, are you going to be part of the public record? And if so, for how long? I mean, again, it all circles back to this expunction question, because there's a lot of people who can't even afford to pay the basic filing fee, and their record may just sit out there forever.
And this is going to be something that ties into what we'll talk about later, some non-disclosures. But the new non-disclosure law actually provides for businesses who receive the order. So a lot of times, sometimes if your record was caught up in a number of agencies, like let's say the bail bonds company, the normal order of expunction doesn't cover that bail bonds company. So you'd have notice issues, and if it was potentially challenged in court, you may not be able to get that party as part of the non-disclosure order. However, the new law says any business who receives this order has to comply with an XYZ. So theoretically, you're going to be able to start serving the orders of expunction and or non-disclosures. We have to take a closer look at the law and getting those businesses who are on the internet, like harriscounty.com or mugshots and such.
Yeah, it's a challenge, because one of the things that I've seen is that the commercial databases take time to update. And depending on the quality of the database and how often they update off the DPS's records, someone may have an expunction which has to be processed locally, then by Austin, but then publicdata.com or Accurate or whoever the database is, some of them update simultaneously, some take time. And so you can have something that's not showing up on the district clerk's website, maybe not even be showing up on DPS's criminal history page site, but it might show up in a third-party database that you are surprised. And then, so I advise people, if you know who's going to run the search for a job, or you know who's going to be looking at your apartment lease application, then you should try to let your lawyer know so that they can contact them and make sure they get a certified copy. But some of them have even said we don't accept copies from lawyers because people have faked expunction orders and sent them off to these third parties, or they've just been flooded with them. So it's just kind of an evergreen challenge that the law is designed to address.
Well, I think we all agree this is a great step in the right direction for, giving people the opportunity to get this stuff off their record. It remains to be seen how it's actually implemented in practice and what the overwhelming effects will be.
Does pretrial even have the manpower? I mean, you see Yolanda and two other dudes that run around pretrial every morning and throughout the day. And that's about it. If every agency in Harris County is now required to do this, are they going to be able to handle that?
Well, I think what you might see is some people just get let go and the officers decide it's not worth the trouble.
Well, that's the other question is how many officers are just going to say, I'm not going to waste the time even filling out the paperwork on this, which it could be, a byproduct of this. I think. I mean, there's already cases out there we know of that cops will kind of look the other way and let people go, and that might be an offshoot of it.
Maybe use the marijuana to get to the
No,
coke,
just
use
you
the
know, even if
marijuana to get the search.
no, just if they pull somebody over and they just decide like, I don't want to deal with the paperwork tonight. It's just weed. I'm gonna let them go. Clearly, if they're given the first chance program,
That's true.
Could be. Next topic I want to turn to, and Tate, I know you're one of the lawyers on this case, so or your firm is handling
Firm
it.
is,
So
I'm not.
I'm gonna allow you to withdraw any comment or anything from it. But it's the case of death row inmate Larry Swearingen, and it deals with the DNA testing battle that's going on. The Court of Criminal Appeals continued to deny him DNA testing this past week. But it's really what I want to get y'all's opinion on is the outrageous statements made by the Montgomery County District Attorney Brett Ligon. Because this just blew my mind. He came out and said that he's been offering to do additional DNA testing since 2013 under one condition, that Swearingen's attorneys agree that if the findings come out and he's innocent, they can still execute him. I'm just, something is not computing there.
No, I don't know how an attorney ethically could agree to that. There's just no way. And if the contract is with the defendant, I don't know how they could possibly be bound by that either. So it really makes no sense. It's, I mean, the simplest thing is to do the testing. I think it's simplest for everybody.
So I'm not completely up to date. Are there limitations on not changing the outcome of the case? Are there, why are they being able to request or asking for DNA in the first place?
Well, the lawyers are fighting for it, but what this really comes down to is Ligon has said, hey, I'm offering to do it just as long as it doesn't change the outcome of the case and I can still have him executed. Which, you get to the ethical part for the attorney, whether or not the attorney could ethically agree to such a thing. My question is, how can Ligon even ethically take that position?
I think it's just hyperbole.
Yeah.
It really has nothing to do with the opinion and what's been going on, which is a request under the Code of Criminal Procedure to have this tested. And so the case went to it's actually gone to the Court of Criminal Appeals several times. And so this last time they issued an opinion that said, well, we've already ruled on this before, and there's this kind of common law rule called the rule of the case that says, well, we've done this before, so we have to do it again. And I think it's a little disingenuous because that rule basically says if a judge is faced with the same question of law and the same facts, then they pretty much should go and have the same answer. Well, in this case, they've actually changed the law since the last time they ruled. It now gives courts authority to look at changes in forensics and technology, and it gives them the ability to test biological evidence, and now they're asking for some different biological evidence to be tested. So there was a dissent in the case for that reason,
Right.
And that's kind of what's going on.
This just seems to me another case, and we've seen a bunch here in the news lately, such as the prosecutor in Louisiana who got into he even wanted to threatened to punch out and kill one of the defense lawyers, I think, when they came down. I mean, this seems like yet another example of prosecutors being bloodthirsty to some degree.
Well,
I'm sick and tired of hearing I need 3 trials or I need 4 trials so I can be promoted in that office. So you tell me this case should be dumped or these things should be looked into, but there's policy that I have to do X, Y, Z, and so you're gonna have to just try this case and see where the pieces fall. It's that attitude. It's the same thing over there in Montgomery County. This guy's saying, you know what, he's had his day, even if he's innocent, and it comes out that there's some DNA would make a difference. Don't change the outcome. I mean, that whole line of thinking is just backwards. I mean, shouldn't it be like let's pursue justice and not have this trial? And we can do something alternative or dump the case, or shouldn't it be? Should we pursue justice and maybe see if this of this individual can be exonerated through DNA evidence?
Well, I think you hit the nail right on the head, Julio, and that is the mandate should be to pursue justice, whatever it may be, whether it is to carry out the death penalty, or whether it's to find someone innocent and free them based on the evidence.
There has to be limitations on that statement. I cannot believe that any man would say such a thing. There has to be limitations on that statement. There has to be.
There may be. I mean, look, you always have to question whatever, take with a grain of salt sometimes what the media writes, but I'm still, even if there are limitations or whatever, this statement is a little troubling to me. I want to turn to some federal stuff that's going on nationwide, and the first one I want to talk to is an interesting issue regarding attorney-inmate emails. I've long been a proponent. I don't know and Alex, I know you were a federal public defender up in New York, Albany, I believe it was, before coming down here. And Tate, I know you do a lot of federal work like myself. And Congress is now trying to propose some legislation to ban prosecutors from reading inmate attorney emails, which is all well and good in theory. But how do you implement that in practice?
Let's see what they actually do first, because they've never put Brady into the U.S. Code.
Yeah.
And they didn't even do that after the Ted Stevens trial, where there were egregious Brady violations of one of their own. So when they actually put something for the defense in the U.S. Code, then I'll talk about it.
Well, and they didn't even, President didn't even issue an executive order, which he could have easily done.
No, they don't. And it's one of these things where President Obama's actions in many cases have been criticized as saying one thing and doing nothing or another. The president could do things with the DOJ in the 8 years he's been in office with the same attorney general up until now his last year in office. He could have done a lot of things like making an official executive order on a uniform discovery policy in Brady nationwide for the DOJ. He could have done some of these other things through the Sentencing Commission. And so you can be president for 8 years, show up at a prison in Oklahoma your last year, tell everybody how good it feels, and then not do anything. And so that's why I say let's wait and see what the president actually does. He's the world's best promiser.
Well, he ran on hope and change.
I know, and we get half of it.
Yeah, we got a bucket.
But I'm a Democrat.
I think the excuse used was that we don't have enough resources to divvy up the attorney email and the regular inmate mail. I think that was one of the excuses.
Well, even if they successfully craft some legislation, which I'm not sure they can. I mean, they have all these things like special administrative measures that, if you're in some kind of national security case, give them access to. I mean, you really have to give them access to everything. So, leaving that aside, I would never trust email of any kind for secure communications with a client in prison. So, at best, it's for things like, I'm going to call you on a secure line next week, or I'm going to come visit you. But to talk about a case in email, I think it's even less secure than the letters you send. So,
and I think that's exactly right, because when you go through core links or whatever, you have to assume one thing we've learned from Eric Snowden, it's that you have no secrets online.
Exactly.
I don't care what your contract says. You have no secrets online, and certainly not in the Bureau of Prisons. The issue to me is one of convenience, is that when you have to drive 45 minutes one way with no traffic to Joe Corley to visit an inmate, to tell him something, or you can send a core link, it should be like the phone calls. You can have them identify the lawyer communications and set those to secure. And ultimately, it would save the government money, because if you're a CJA, if you're appointed to represent an indigent criminal defendant in federal court, they have to pay you for that time to go visit them, to have a conversation where you might be able to communicate something faster by email.
But also, doesn't that, speak to, for those who don't know and aren't familiar with how federal inmates are housed awaiting trial or awaiting sentencing, they used to be housed in a thing called the Federal Detention Center here in downtown Houston, and then all of a sudden, the marshals got into a little argument with BOP, and they built their own little private prison up in Montgomery County and moved them all 45 minutes away, one way, as you pointed out.
With no traffic.
With no traffic. We talked about this last week about private prisons, but shouldn't we really look at the system overall and make it better. I mean, why not bring everybody back to the federal detention center? All the lawyers are in downtown that are representing these people.
What's there now? Who's housed there now? I mean, who's there?
Other inmates are, but I'm not sure it's big enough, in all fairness.
Well, I think what they've done is now they've kind of moved people here to the federal detention center downtown that have sentences of a year or less, and they've kind of used it as a quasi halfway house, so to speak, for people who are on their way to the halfway house.
Well, in most districts, there is no FDC. There are county jails. And in fact, when I started practicing, federal prisoners were in the Harris County Jail. But when I was in upstate New York, you'd often have to drive 3 hours to get to a county jail where an inmate was. And so there is no one way to do it. If it's cost effective, they'll build a facility. If not, they won't, and you have to just deal with it.
Well, they're building that inmate processing center.
Right.
What do you know about? Do you know anything about that?
Yeah, I've seen the blueprints for it. I've been to many meetings about it. It will replace the city's jails. So HPD will no longer bring people to their jails or their substations first. They'll go straight to this processing center, which is what the sheriff does, which is what most of the other municipalities do. They bring them straight. But it'll be a larger area than they have now for processing people. It's also hoped that will be a place to process people out, so that hopefully there'll be some reentry programs to get people out of jail. The county judge has talked about how to divert people there. Right now we don't have any kind of system for that and a place to divert people, but
Not like a trap door over the
there's
place.
no right now. There's no like a separate door. So
Funny.
all these programs that we want to do, these first chance and other diversion programs, we don't really have a mechanism yet in that system to deal with that.
And there's nothing like the core links system like you talked about, Tate, which there's nothing like that at the state level. I mean, we can't communicate with inmates at the Harris County Jail or at the soon-to-be inmate processing center.
It really is kind of a facility-by-facility contract, is my understanding, is that, the systems that run the phones in Fort Bend or video visitation may not be the same in Harris County. And, I mean, that's just because you have you devolve local government on counties in Texas. So,
but I mean, even in the face of, and I kind of joked with somebody the other day because this proposed legislation, what they proposed was just merely the ban itself, but it gave no punishment. I mean, the reality is, if they can get it, prosecutors are going to read the communications between an attorney and their client, even though they know they can't use it and they never would. But
I've had this come up in a case where I found my mail and my calls in discovery, and it was fine because I couldn't show any prejudice because I trusted the prosecutors involved. They were both good people, and they said, "Tate, we got to this point and we saw what it was and we stopped." And I listened to the calls, and in good conscience, I couldn't go to the court. And I had to file the motion to get there, but after I learned what had happened, we reached an agreed accommodation. When they answered and they told me, my concerns were alleviated, because the most important thing to show in a criminal case is harm or prejudice. How does this hurt me and affect my rights? Because we all know that the Tasmanian devil of Texas courts is the harmless error rule, and things that sound a lot like it. So you can say, oh, there's this great violation of law. It's horrible, it's horrible, it's horrible. And the courts want to know how it affected the outcome of your case. And so if you're going to make an argument on anything like this, even if it affects, they say harmless error doesn't apply when it affects structural constitutional rights, which you would think the right to counsel is one. I still think you should err on the side of arguing harm and showing it if you can. And that's the deal, is that accidents happen. People overhear privileged communications. You have like a snapback rule, like if you get an email you're supposed to let them know. Lawyers have been disqualified for invasions of the attorney-client privilege. Sometimes accidental, but it was in a situation where you could show prejudice or harm.
Yeah. We're coming up on the halfway point of our show right now, and I want to remind everybody we're going to open up the phone lines. 713-807-1794 is the number. We'll take your calls right here live on the air. We've got Twitter up at HCCLA_TV. But right now, I want to send you to our 60-second law lesson. This week we have Lisa Shapiro-Strauss, and she's talking about DPS issues. Lisa.
Have you ever been on the DPS hamster wheel? And by that I mean, have you ever received a ticket that you didn't pay on time, or you received a DWI and you had your license suspended? Once you get on the hamster wheel, it is very difficult to ever get off. The reason being is that once you get a letter from DPS and they say that you could request a hearing, if you don't request a hearing in enough time, you're going to automatically have your license resuspended. If you get pulled over for driving on a suspended license, you will be taken to jail. And in addition, after you get out of jail, you will most likely have your license resuspended for another 6 months, another spin on the wheel, and you will have to pay more surcharges. So once you get involved with DPS in any way, it is my advice that you contact an attorney to help you so that you do not get stuck on the wheel of DPS, on the hamster wheel. My name is Lisa Shapiro-Strauss, and that was my 60-second law lesson.
Thanks, Lisa. Great advice. If you want to catch all the rest of our 60-second law lessons, you can go to our website, www.hcclatv.com. We have them all posted up there. If you think you have a friend who could use some of the advice you see right on there, send them our way. And I'm sure we got a lot of stuff on there that could be very useful to people. Guys, I want to talk about another federal issue, and of course it's been big news. We've talked about it here on the show several times, and that was the release of over 6,000 federal inmates this past weekend by the BOP. Again, Tate, all well and good when you show up and at a prison and you talk about this, and it is a good thing, but it barely made a dent. Really, I mean, it truly barely made a dent in the system.
Jimmy, how many people live in the United States of America?
Over 300 million.
Right, and what's our population, jail, parole, probation population? It's like 1%, right?
Right.
The highest per capita in the world, certainly the highest on any basis in the free world. So 3,000 is roughly, I can't even know how many zeros to put between the decimal point and the 1.
It's like a trace case. You know, you can't, it's not even barely measurable.
I would say it's a drop in the bucket, but it's not even humidity.
Well, and the other thing too is there's a little over 200,000 federal inmates. Okay, so we might be dumping that number to under 200,000, but what this doesn't account for the millions of state inmates that are still out there. It doesn't do anything for them.
2 million.
Yeah.
2 million people behind bars.
But you have to put the number in a context of when it started. The Rockefeller drug laws in New York, the end of the civil rights movement, the 1970s. All of this is a very recent phenomenon within you and I's lifetime. We're not going to date you, Alex. So, I mean, this isn't traditional America. This isn't even 1950s America, Eisenhower America. I mean, you haven't had this many people in chains since before the Civil War. It's ridiculous.
Well, the federal laws that created this mess were an agreement between Ted Kennedy and Strom Thurmond. I mean, it was that kind of, everyone got together and said, we really need to do something about drugs, meaning at that time crack cocaine.
Right.
Len Bias was a basketball player in Boston who died. He was drafted by the Celtics, and Tip O'Neill said, we got to do something about this. So they got this, there was no thought behind a lot of these laws and what they meant. And so they passed mandatory minimum punishments, they passed the sentencing guidelines, and we're just kind of getting out of that now with these small changes in the sentencing guidelines and reduction of mandatory minimums to get back to some kind of normalcy. But a lot of people paid a lot of time in federal prison before we did any fixes.
We got our first phone call coming in. We'll take a little pause there and we'll come back to that, but I want to jump over the phone lines. Hello, thanks for calling Reasonable Doubt.
How you guys doing tonight?
Great.
Listen, about this, I just got out of prison myself a few months ago, and to me, I'm going to go against the grain about letting the drug offenders out and the mandatory minimums and all that. But in theory, it sounds good, but I want you guys to discuss, how many of these drug offenders do you think care to work jobs? They might go, you will hire them back, and they'll gladly hustle and sell drugs once again. And the next designer drug is going to come out. They're going to sell it. The next thing, it was crack in the 80s, meth in the 90s to the rural population. What will it be this next time? And do you think these guys really are going to work when they get out? I mean, let's just be honest.
Well, let me ask you, what was your experience? I mean, what do you base that on? Do you have some?
Everybody down there, when I was in the Texas prison system, it's like they don't want to work, and it's generalizations and stereotypes, but there's very few people. They'll be glad to work for a little while, but that fast money drives them, and to me, these guys, they're going to get out. They'll try to go and conform for a little while, and then they're going to go back to the easy money. They have bills to pay and mouths to feed, and it's just the sad truth, and it keeps you guys in business,
Well, I appreciate the take, and thanks for the call. It's an interesting
Absolutely.
take from somebody who was on the inside.
I think, though, that it sums up everyone in the same situation, and that's not true. We had so many different kinds of people that got caught up in that. When I was in Mobile, we had a woman who was a single mother, who got 20 years to do because basically she was the girlfriend of a guy that was in a drug trafficking conspiracy. She had nothing to do with it, but there was no one else she could give up. So when they came to her and said, we need you to cooperate, there was no one else to cooperate. Everyone had cooperated against her. And on his last day as president, Bill Clinton commuted her sentence because it was just a travesty. But there were so many cases like that I saw. And so those were people, they weren't going into the drug business. They weren't career criminals. They got caught up in maybe a one-time thing. And they ended up spending a lot of time in prison because of it.
Well, and this release, this sentencing reform release that got these people out, is all about drugs. It affects no other else. And I think what's been, I guess, I don't know the best way to put this, but they put it out there publicly as nonviolent offenders. Well, hell, there's a ton of nonviolent offenders sitting in jail, but they're not reducing their sentence. And not to take up for the guys like, Bernie Madoff and Alan Stanford and all that. I'm not going to try and take up for them, but there are guys doing 50, 60, 70, 80, 90, 100 years on nonviolent crimes. And this is the line they're singing?
I think that the problem is that, first of all, you have overcriminalization.
Yeah.
Nobody wants to talk about that. It's all well and good to talk about sentencing reform, but if the Heritage Foundation and other people that have tried to identify all the federal criminal laws on one source can't do it, that's a problem. And then you have wide discretion with charging decisions, whether it's in obstruction, false statements, party liability. But even once you get to people who are appropriately convicted, appropriately sentenced, and regardless of how long they're doing, if you don't have meaningful reentry programs, then you are setting people up for failure because of exactly the issue we talked about. There are companies, even just if you talk about the internet companies like Accurate and Republic Data, that are providing accurate data to their customers, as they're legally allowed to do, to people who have valid interest in obtaining that information. It's still a handicap for somebody who's trying to start over, because even if they're legally allowed to get a certain job that doesn't require a professional license, who's going to take a chance on it?
Well, there's a bill that was introduced. It's in one of the articles called the Safe Justice Act,
Right.
which actually addresses the problem on the front end.
Which that bill parenthetically has died.
Which is dead in the water, which it's over, right? But what it does is it starts a presumptive probation for qualified offenses under federal law. It will decriminalize crimes that are crimes now, and then it will implement diversions. So to stop the individual from going into the system in the first place, that's dead in the water. Because private prisons don't want that. But these are some parts of reform that will stop the flow inside, and then, for everybody outside,
But for the people that are there, if you go back and you look at, so TDCJ has a great reentry program that they do at the Carol Vance unit. Carol Vance was a prosecutor, the DA before Johnny Holmes. It's a faith-based program that provides mentorship. You're released out the back gate, helps people get jobs before they come out. There's a women's reentry program here downtown called Bridget's Hope. But the key to those is individualized attention, patience, helping people find employment, find housing. It's like dealing with a homeless person with a really bad criminal record. And look at how challenging it is just to get housing and employment for the homeless of this city and everywhere in the country.
Yeah, and we talked about the mandatory minimum problem that was out there, but Tate, you and I were talking about this the other night. There are a ton of other statutes out there that provide for no eligibility for probation. I mean, bank fraud. If you go out and you make a false statement on your mortgage application and you get caught and hit for bank fraud, guess what? You can't get probation. Or this new fraud in connection with a natural disaster that came out following Katrina, that's a non-probation eligible statute. So if you even go out and file a false $1,500 claim with FEMA, you get charged by the feds, guess what? You're not getting probation. I mean, there's laws like that too that are out there.
Well, but they're not a deterrent because nobody knows.
Right.
When they first passed the penal code, it was this thin. And then periodically they go through in the Texas Penal Code and they reconsolidate like the theft statute. And then special interests come in and we create a bunch of extra laws to address like cable TV theft and things like that. When really theft is theft. You should just have one basic statute, let the common law do the rest, and then you don't have to worry about all these special interest crime bills, just like special interest earmarks on spending that nobody knows about. And then when you're like, this is ridiculous, you say, well, ignorance of the law is no excuse.
Yeah.
Right.
We got another call coming in. I want to jump over to our phone lines. Hello, thanks for calling Reasonable Doubt.
Hi, I have a question regarding the diversion procedure that you talked about earlier.
Yeah.
Will this be applied retroactively to cases awaiting trial? And I don't know whether there's anybody in jail for possession less than 2 ounces of marijuana, but how will it impact them?
Sure. Thanks for the question. I mean, I guess we're going to see how that plays out.
I think it's a practical matter. There is no cases that have been sitting around. These are Class B cases, so they travel through the system fairly quickly.
Yeah.
And so I don't think there's anything first chance program that's pending that wouldn't have been eligible.
What do you mean by that? They travel through quickly. I know what you mean. But
Well, the maximum sentence for Class B is 180 days. So.
right, but your average trial time, if you actually fight one, is 6 months to 2 years.
If the defense bar put a united front and said we are fighting every single marijuana case, one of two things will happen. One, the entire judicial system here in Harris County would crumble, and we would remain victorious, or that's about all that would happen. If we fought every single marijuana case, we would we'd crumble the system. I mean,
well, we'd force them to change the system, which is, I mean, like I said, this is kind of what they're doing now. But another thing that came out this week, guys, was President Obama again trying to make a stab at doing something hope and changey, and that was ordering the federal agencies to stop questioning people's criminal histories.
Until a point.
Until a point, that's right. And why don't you expound on that?
Well, they say that you need to look at it later in the process. It doesn't say you can't use it as a factor in considering them for employment. So what, they go to the third interview before they get the bad news?
Yeah. Again,
I mean, it's
open change.
Right. It's called Ban the Box, and it's kind of a national trend to not, keep people from even coming in the door. So, they may have qualifications and employers may be interested in them, but if they never even get in the door, because once they sign the form and say, I'm a felon, or I have a prior arrest, or whatever is the disqualifying factor for that employer, I mean, they can't even be seen and shown, why they should.
Yes, you're right. And that's the hardest thing, as we all know from trying to get jobs, is to get that first interview and give somebody a reason to take a chance on you.
Well, and going back to our first caller, I mean, he said that a lot of these people will probably just go back to dealing drugs or using drugs or whatever it is. But I mean, when you show up at a job and you can't even get a job, making coffee at Starbucks because you have a criminal background, I mean, where else do these people turn?
Right.
I'm not familiar with the federal laws, but are there remedies or ways to clean your record on the federal side?
No.
Is there?
No.
It's permanent.
Wow.
You can't get that stuff off with rubbing alcohol on a wire brush. I mean, it's not coming off.
There have been some judges that have tried to do that, but it is not. I know of no successful cases of kind of in their own administrative capacity to expunge a record.
Well, and there's been all this talk about restoration of voting rights and sometimes gun rights, but that's
a state law function.
Yeah, and that's almost impossible.
The problem there is that you have, on the gun rights, you have the federal and the state. So in Texas, you get restoration of gun rights under certain circumstances, but you still have the federal problem. And there was the famous Supreme Court case, 5 years ago, about the man who got a conviction in Mexico because he had ammo in his car. He got exchanged to the U.S., and he petitioned to get his gun rights back, as you're allowed to under law. It's just that Congress never funded the agency that processed the applications. And so he sued in federal court saying that's tantamount to a denial. And they said, well, you have to get a no before you can sue in federal court. And he says, I'm not going to get a no because they don't process the application. And the answer was tough luck.
Right.
So, I mean, he comes out with this feel-good thing about not checking criminal histories, but is there a solution to that? I mean, what kind of things could we do that would make it more meaningful to help people in terms of getting a job?
Well, I think there are limitations to it. I think it applies to federal jobs or jobs with the government, and then and the time limit of when they can.
There are some states that restrict the use of criminal background information. I think Wisconsin has a pretty progressive law on it, and other states do too. I'm sure California's at whatever extreme there is in protecting it, because they usually are in general. But Texas, we don't have that. And
right.
You have, in fact, on the non-disclosure orders, you have a list of agencies that are exempt from an order of non-disclosure.
Yeah, and it's actually worse than that. We build into our laws collateral consequences that prevent people from working. So you have a conviction, you can't get a barber's license in Texas. There are all kinds of job limitations from a conviction,
Right.
that are just automatic.
Well, I mean, back to your point, Tate, I mean, it's just a lot of rhetoric and no real solutions on these things.
Well, Texas, like we were discussing earlier, the new non-disclosure law, read up on it. You're going to be able to non-disclose certain types of convictions, and you'll be able to get those done if you're within time periods and follow the law. So that's something that's opening the door to helping people get jobs or cleaning up their record.
We got another phone call coming in. We're burning up the phone lines tonight. Hello, welcome to Reasonable Doubt. Thanks for the call.
Question. Are courts required to advise when eligible for extension?
Is your question, are courts required to advise?
Yes.
Okay. Julio, you want to take it?
Okay, this is a new change in the law as well. Currently, no, at least on the state level, no, they don't have to advise. However, the new non-disclosure law will provide a mechanism for the judge to either say, when the sentence is pronounced, I'm going to go ahead and let you non-disclose your record, or I think in the interest of justice, if you do X, Y, Z, you conceal your record. Additionally, it allows the judge to say, to make a finding on the record to say, and in the interest of justice, I'm not going to be okay with you petitioning a non-disclosure, and you won't be able to. So I think currently there is no admonishment from the judge to the individual about a non-disclosure, but the new law allows the judge to make certain findings on the record and affect your ability to seal your record in the future, one way or the other.
Isn't it a little disingenuous that we have all these admonishments, even to citizens, about if you were convicted, you could be deported, but we don't admonish people on their rights to get an expunction or a non-disclosure if they qualify?
Well, I think we have to admonish people about loss of gun rights now as of the last legislature. The question I have, though, is for Alex, what do people who are indigent do if they're eligible for a non-disclosure or an expunction? I mean, they can't come to the PD's office, so how do they get around the fees and things?
Well, we try to refer them to lawyers that will do it at a cut rate fee, but we can't do them. We don't have the funds to do that, and it's not part of our mission. So I think that is a real failing, and there should be some mechanism for indigent people. And indigent people get stuck with all kinds of fines and fees. And Janie Maselli in my office was filing a number of appeals about that very issue. And the one thing we did get out of it was courts are now required to give them written notice of what their fines and fees are, because they didn't do that before. It was just in the computer and they didn't know. And what we realized was a lot of them were wrong. So they would have a witness fee in a case where no witness was called. They would have different fees that didn't apply. And if you're going to prison, if you're going to TDCJ, they're going to take that out of your account. That's money you need for commissary, and they're going to take that money away from you, and it might not be truly owed. So that's one thing that's been going on.
We've got another call coming in. I want to jump over to phone lines. Hello. Welcome to Reasonable Doubt.
Yes, to change the subject, there's a new law on the books about possessing photography from drones on property you don't own. Can y'all talk about that? Because
Possessing photography from drones on property that you don't own?
yes, I understand that was put into the state passed a law about that, and it went into effect. And possessing images from drones, if you don't own the property, is now a state crime.
I think we'll talk to Mark Bennett.
Yeah,
That's a First Amendment
That does seem
case.
like a First Amendment case to me. I'm sorry, I'm not aware of that law. I'd have to go look it up on the new drone laws.
Well, the drone laws are going to be a subject of controversy for a while because of the way the FAA is going to regulate them.
Absolutely.
You know, licensing for people like they do for big model airplanes. You're going to have the state laws. You're going to have the privacy interest laws. So Texas, part of their, the improper photography law, I think was a little over aggressive. But that's a great topic from Mark Bennett.
Can I shoot a drone if it's going over my property?
I've been looking for the answer to that, and as soon as I figure it out, I'll call you and let you know.
It's not endangered, so I guess it's okay.
Alex, since we have you here this week, I want to ask you how things are going at the PD's office, because you came down here from New York to set this thing up. You've had it blowing and going for a while now, and there was a little bit of controversy.
I'm sure there was
when the whole thing was implemented.
Yeah, by the time I got here, it didn't seem very controversial, but I know it was. I started practicing in Harris County. I went to South Texas College of Law. I got out in 1986, so I started back when there was no Fair Defense Act, and lawyers were paid only for settings and not out of court work at all, and lawyers slept through capital murder trials. So I remember those days. I went away, I became a federal public defender, and when the opportunity came that I could come here and start an office, that was very appealing, because Harris County was the last of the major cities that did not have one. But I didn't really find a lot of opposition in the beginning. A lot of things to do. We brought in a lot of good people. A couple years ago, there was actually a study done on our office. It found that the work we were doing was valuable, that we're trying more cases, we're getting better results. We're small. We have probably 8 to 9% of the whole docket, because I only have about 45 lawyers. We all have very strict case standards that we have to follow. But what I see our office being is not to take over all of the assigned cases. It's to kind of set a standard of competent representation to help bring up the standard of practice for appointed counsel, and to help the lawyers, the private lawyers that are getting assigned. One thing I would like for them is to get paid better. I mean, we found out that they're only getting about $84 per misdemeanor case. That's ridiculous.
Well, I know Julio does a lot of appointments on the state side, and Tate and I take them on the federal side. What are the biggest challenges you see out there right now for non-public defender lawyers?
Well, I think that we don't have any kind of caseload standards. So there are some lawyers that have way too many cases, and it doesn't matter if you're the best lawyer in town. You have too many cases, you can't do a good job. So I think that needs to be addressed. I think the resources need to be addressed. They need access to investigators. You cannot go into a courtroom, look at an offense report, talk to a prosecutor, talk to the defendant for a few minutes, and have any expectation you're going to do a good job for them. When I got here, Jim Leitner was the first assistant district attorney. He called me and said, sometimes we get these cases where somebody's pled guilty, and then several months later we get the lab report back, and it's negative for drugs. And I said, really? He said, yeah, and we don't know, we can't do those cases because we can't file a writ. Would you do that? And I said, okay. And then the current district attorney, Devin Anderson, instituted a policy to help track these cases. We found out there were a lot of them. So I've got a lawyer in my office, Nick Hughes, who's probably the most prolific writ lawyer in Texas. He made Harris County last year the biggest district for exonerations in the country, because we found all these cases where someone had pled guilty and it wasn't drugs. So you can't just assume, even if the defendant says, oh yeah, that's fine. There are issues in the case. There may be suppression issues. There may be legal issues. You cannot, take too many cases and look at an offense report and make a decision on what to do that morning. Yeah.
Let me ask you, do you see the PD's office going into PC court more, or are there ideas of how getting a defense lawyer right at the get-go could help a lot of people?
Yes. There's a lot being done to look at how to improve our pretrial procedures in Harris County. We're looking to institute some more evidence-based practices so there's a real risk assessment done so that the magistrates can rely on that and not have to answer to 32 different judges about their preferences, but also to have lawyers at that. That's what I've been fighting for about 4 years now, and I think I'm starting to get a little traction, and we may have a pilot going, at least maybe for mentally ill clients, to get them, because if you get people out early, one, they don't lose jobs, they don't miss school, they don't do all the things that are bad, but also we know that when people are in custody, they have worse outcomes in their cases. They're more likely to be convicted, they're more likely to get a custody sentence, they're more likely not to get some kind of supervision sentence.
Realistically, you said you had 45 lawyers in your office right now. I mean, how much more can the office grow? How much of a support is there for the office to grow, and by how much more?
Well, it remains to be seen. I mean, we have the whole 13th floor. I still have a few empty offices in terms of, physical plant. We're getting kind of there. But as I said, what I really hope to do is improve the work for the private assigned counsel, give them more support, make sure there's better review, maybe some peer review of who's on the panel, and work on that. Because I don't think I don't know that us taking over a huge number of those cases is necessarily going to be the best thing. It may reduce the quality of the work we're doing. I want to make sure we're doing as good a work as we can with the people we can.
I think there's a ripple effect from your work that's actually in working conjunction with the bar organizations too. I mean, I use resources that y'all have, for example, your expert bank, and people that are there. If I know I have a question on something, even if I can't get my normal immigration lawyer on the phone, the people in your office are always happy to help, and even as something for jail clothes for someone. And but I think that's really setting a standard, being a resource that benefits everybody in the local criminal justice system.
I will say, resource as intellectually, but also when you see a PD in the holdover, the level automatically is raised. The bar is raised in that room. And that's the kind of image that the PD's office is given.
Yeah.
And with that, we got to go, guys. We're out of time. Alex Bunin, appreciate you being on. You're doing great work over there. Tate Williams, as always, my friend, good to have you on. And you're doing great work as well. Julio, next week, we will be back. Everybody,
really
appreciate you joining us. Go visit our website, www.hcclatv.com. Check out all our guests and past episodes. We'll see you next week right here. Good night.